Good evening to everyone present here. I am Neet Kaur, volunteer of Sambhav Initiative and moderator for this event. On behalf of Sambhav Initiative and Pro Bono India, I extend a warm welcome to our esteemed dignitary, Professor R. Venkataraghavan sir, and to all the participants in this 2 weeks online national capacity building program on art of craft, a contract drafting from fundamental to enforcement, organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and treating legal literacy under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah sir, former Judge of Supreme Court of India, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy, where today's session is all about introduction to contracts and drafting methodology, fundamental and essential requirement for contract drafting, general principles of contract. Before we start the session, please adhere to some webinar etiquettes. I request all the attendees to keep their microphones muted during the session. If you have any questions, please use the chat box or raise your hand. It is my privilege to have with us and honor to introduce Professor R. Venkataraghavan sir, professor at Manipal University. Sir brings with him over 37 years of rich techno-legal experience in construction industry, including 3 decades in international contracts across the GCC region. Sir is a chartered engineer, chartered quantity surveyor, a fellow cost accountant, and a fellow of the Chartered Institute of Arbitrators, UK. Sir also holds a master's degree in construction law with distinction. Apart from his extensive industry experience, Sir is a seasoned academic and international trainer in the areas of construction contracts, claims management, dispute resolution, and arbitration. Sir has conducted numerous workshops across the Gulf and Far East and is regularly invited to speak at international conferences and contribute to leading journals. And has taught at institutions like IIT Chennai, IIM Tiruchirappalli, and the British University in Dubai, and is a tutor with the Chartered Institute of Arbitrators, UAE chapter. Sir is also empaneled as the arbitrator with reputed institutions including DIAC, AIAC, and the Indian Council of Arbitration, and frequently serves as an expert witness in construction arbitration matters. In 2015, Sir co-founded CQ Consultants, a firm focused on contract lifecycle management and dispute resolution in construction sector. At Manipal Law School, Sir is leading the development of new programs in construction law and arbitration, including a master's program and various executive and diploma courses to empower professionals in this growing field. We are deeply honored to have you with us today, sir. Over to you, sir.
Thank you. Thank you for that long introduction. So I have a lot of senior experienced professionals here. I don't know how much I'm going to pitch in because I was told it's a mix of seniors and juniors and middle level professionals. So if you find some of them are little preliminary, please bear with me because when we prepare, we have no idea about the audience as such. So let's get into that. So it will be a very short and sweet because the day one, there are a lot of senior people are going to speak after me during the next 2 weeks. So probably it may be a good idea at the start to brush up our principles of a valid contract and what are the core principles of a contract drafting. So what do we think, what is good one? The second thing is today the contracts have to be drafted for very, very specialized domains. We talk about data privacy, we talk about international investment and commercial arbitration. Of course, we have commercial contracts, infrastructure contracts are there. Then we are talking about space law, we are talking about energy. So there are multiple areas or avenues have opened up and the lawyers have been called in to draft for various specialized domains. So we need to understand how we can adapt the drafting principles to the various specialized areas. Of course, one size does not fit all, so we need to be aware of that. Then very, very briefly, maybe 4 or 5 provisions from the Indian Contract Act, because it was also given to me as part of the syllabus for me to cover that, but I'm not going to cover all the 75 sections. It's beyond today's class, and most of you are very much familiar with the Indian Contract Act. So probably just 4 or 5 sections we will just take an overview. We will just try to do that. So that's going to be the one. So we will take the questions in the end, but if you feel that something is to be important for you to ask, you can always ask. I don't mind to be interrupted during the session. So what is a contract? I do a lot of international training, and whenever I ask this, I get different answers from different audience. So perhaps not everybody's advocates or lawyers in the room. So there are professionals, commercial contract people. So some people say that terms and conditions for contract. Some of them, especially for the senior management, whenever we mention about a contract, they think it's a legal jargon. They don't understand. They will call a contracts manager to review, to provide inputs. And then they would say, like, look, where you want me to sign? I'm ready to sign. That's so the legal jargon. They don't want to get into that. I got interesting answer that some people say it's a fine print. Of course, there are some mortgage contracts and other contracts are all printed in a very small font. And maybe it's actually a bit of a psychology there. So I was told actually when they print a contract in a normal font with a regular spacing, it may come to 10, 15 pages. So the parties may look that it's a very long contract. They need to do a proper review. But if you print a back-to-back A4 sheets in 4 pages, perhaps you give it a single sheet. So then the people think that it's very a small contract, it's a minor contract. They don't see that it's a highly risky. So they don't bother about it. And most of the time they sign it. So that's why probably it's called a fine print. But I would say normally the contracts are not always fine print. We need to read before that's what we say, think before you ink, because once you get into the contract, then you would be, the contract may be irrevocable and you may be paying damages for the breach. So, but when we think of a very simple definition, of course, textbook and all will give a very long-winded statements. So the best statement I normally like is a legally binding agreement. So I don't think it can be shorter than that. So there are two limbs to that. One is the legality, the other one is the agreement. Of course, we are talking about commercial contracts, so we consider all of them are legal contracts. We are not contracting for any illegal activities. So we will leave that out of the discussion. The other thing is any contract which is formed is enforceable at law. That's what the legality is all about. So in many commercial contracts, there is no requirement for any uh, legal formalities or notarizing it or registering that. Some of the contracts may require that, but I'm not saying. But not every commercial contracts have to go through that rigorous legal requirements. But however, whenever a contract is breached, the innocent party can always go to the court asking for his remedies. So that's why any contract which is formed between a commercial parties or any parties is legally binding on the parties. The other one is the mutual understanding of the parties. That's what we call it, agreement. That is quite important. So the enforceable at law and mutual understanding of the parties. In addition, beyond that, contracts need not be like very specialized data privacy contracts or a construction contracts. In fact, there was actually a saying, the commercial world cannot perform without the principle of a contract and contract law. Think about it. You go to a shop, buy a loaf of bread, give 100 rupees. You made a contract. There is an offer to buy, there is a consideration, there is an acceptance. You walk away with the bread, you formed a contract. You park the vehicle on a parking slot, you take a parking slip, there is a conditions overleaf, you paid the money, you park the car, you're enjoying a service for which there is an offer acceptance. So we can keep on going that every day we form the contract, we perform them, and we move on without even knowing that we have performed a contract. So it's as simple as that, as basic as that. So in real life also, there are a lot of real contracts. In fact, tenancy contracts, employment contracts, even marriage is a contract. Maybe it's a social marriage. At the time of marriage, you may register, you may not register, you may not bring in any kind of a legal requirements. But if at all you want to break a marriage, definitely you need to go to the court. So tenancy and employment may have some kind of regulations, but other than that, these are all contracts. So what I'm trying to tell, the contracts are everywhere for us to do that. How a contract is formed, basically, there is an agreement. Yes. Again, that agreement has two limbs. There is an offer, there is an acceptance. Then when the offer and acceptance correspond in every respect, we say there is an agreement there. Now, coming to these two terminologies, which are all very simple English words, I just wanted to highlight that there is a little bit more than the English meaning when it comes to the legal parlance. A offer is basically an expression of willing to contract. Of course, when I say that I want to sell my car for 3 lakhs rupees, so you are the buyer, then that means I'm making an offer to you to sell my car for that kind of a money. So that is, there is a willingness to contract. But there is something more added to that. When we talk about an offer, it is to be made with intention that the offer shall be become binding. So I cannot make a reckless offer, right? If at all I wanted to make an offer, I should definitely know that if the offer is going to be accepted, then I'm going to be bound by that offer. So that intention that it shall become binding, that's quite important. That's why if you remember in the government contracts or even commercial contracts, we have something called a tender bond. Because let's say that you gave a very low offer, the other party is going to willing to give the job to you, the contract to you, but you are not willing to take, then you will forego the tender bond. The reason is you don't provide a reckless offer. You take seriously whenever you are providing an offer. So to ensure that you are serious enough, to make sure that you will not just give a just a low bid to drop the prices down. So there is a requirement of a tender bond in a government contracts, construction contracts. So whenever we make an offer, that means there is an intention that's very important. Similarly, when it comes to acceptance, there is something very important. It's unqualified expression of the terms of the offer. That unqualified is very, very important. Let's go back to the example of I want to sell my car for, let's say, 1 lakh. It's an old car and I'm ready to give it off. You're saying that your car is okay, but 1 lakh is high. I can pay you maximum 75,000. That means you did not make a acceptance. In fact, you're qualifying that acceptance. That is actually a counter offer. So in commercial world, this happens very often that there is an offer made, the acceptance comes with a counter offer with their own terms and conditions. This goes back and forth. We call it a battle of forms in the contract law. So there are times where the tribunal or even the judges have to really find out at which point of time the contract was really signed. There is a funny case actually in Dubai when I was working. Very expensive ironmongery was bought from Germany from a supplier. So the supplier terms and conditions and the purchase order terms and conditions were very different. And it was going back and forth. And finally, when the material was supplied to the site, the storekeeper have accepted the material and he has signed and stamped the goods received note without knowing what it is exactly mean. Then at the end of the day, the judge concluded the contract was formed at the time when the material was delivered and it was accepted by the contractor from the supplier. The problem was actually there was a shortfall and the shortfall have to be informed within 15 days as per the supplier's offer. Whereas the purchase order says that 3 months time the contractor has to notify any short supplies. But because the contract was not formed at the time of purchase order or even acceptance, finally they have to conclude that when the goods received note and it was signed, that is actually the real contract formation happened at that point of time. It was very funny actually. The storekeeper doesn't know that he's signing a contract, but even the supplier who brought the material would not have had a thought that he's getting into a contract with other party. But this is how it has been considered when it comes to these kind of conflicting terms and qualified acceptances. So again, when the contract form it becomes irrevocable, that's a thing we all know about it. Acceptance must be in writing. I would say preferably because most of the time we all know that more than the express terms or the whatever we are reading it, there are a lot of things which will be implied in the contract. Let's say that you are a owner and you have a piece of land and you want the contractor to come and start the work in absence of a written contract or written order. Perhaps the contractor comes and do the work on the weekend, and after that, if you find a better offer from another competitor, you cannot tell the contractor that pack and go, that there is no valid contract because I did not give you a piece of paper. Because having admitted the contractor to do the work at site, if it is not his intention, that is a trespass. He would have gone to the police. So in this case, he has allowed the contractor to do the work. So that means definitely it is there is an acceptance, that's an implied acceptance. So that would be the considered as this thing, as good enough for a contract to be formed. Consideration, again, we all know about it. It's again, it's not a just an English meaning. So something is given or promised, that's in law. So basically, consideration for services, consideration for good. So this happens. The only thing what we need to remember about consideration is basically to have a binding contract. There has to be an element of consideration. Otherwise, it is not a valid contract. But there is no need for the consideration to be adequate. This is very important. Lots of times the contractor argue the price of that contract or the work is much more than that. How can the owner can ask us to do for a smaller price, although we made a mistake and we need to be compensated? That doesn't really work. If you accepted a contract, that means you have to fulfill your obligations. The court or the tribunal are not going to rewrite the contract, whether it is justified or not justified. So the consideration, you need to take care of that. So to recap, there has to be an offer, there has to be an acceptance, there has to be a consideration. When we talk about capacity, I'm not talking about minor and other things which we normally teach at the college. When a lot of times what happens, this happens even in the Middle East, you may be thinking that you are doing a work for MR or Nakil or Dubai Properties or a very big developer. What they do basically, sometimes they create a lot of sister companies with a limited liability, and they will make that contract signed with that smaller outfits. When that is happening, you are not really signing the contract unless you have a parent guarantee and other things. You are signing with a limited liability company. Their liability may be very limited. Tomorrow, even if you win against an arbitration, there could be a problem in getting your remedies or your money, because there is no assets available for them. So you need to, at any time whenever you are getting into a contract, you need to see that the other party has assets to pay your dues. It may be during the contract, during the performance, or probably they are not paying and you go to an arbitration and get an award in your favor. Then also the other party should have deep pockets. So that's why if you look at it, construction contracts internationally like FEDIC and all, there is a requirement for the owner or the employer, which FEDIC calls it. They have to show that there is a financial viability for the project is there. There is a requirement, and if the employer did not perform that, did not fulfill that, the contractor has the right to even suspend and terminate the contract, because the construction contracts are highly risky. The contractor would be at a receiving end if he starts the work, and after that the employer is run out of money. So that's the reason it's very important for you to know that the other party have assets to pay. Of course, we all know the Indian Contract Act. I'm not going to deeper about that. So that's the kind of a just a very brief introduction for us to get into the specialized domains. Do we have any questions at this stage, or can I continue and take the questions in the end? Am I going at the reasonable speed, or any suggestions? Anything is fine?
Yes, participant, any question, query from your side till this
If the
time?
speed is okay, or am I rushing? I just wanted to have just a small feedback. Uh, If everything is fine, I will continue. So you don't have any questions as of now, right?
Yes, sir. Yes, sir. Please go on, sir.
Okay, fine. Then we'll proceed, probably. So there are three contracts. We are going to talk about three different type of contracts. One is the construction one, of course, that's one. Then I told you about data privacy. Then I'm going to talk about the international investment and commercial arbitration. So these three things as a specialized domains, we take it, and we will try to very briefly see that how the things are really made up of these contracts. Basically, here the construction contract is you supply materials and provide the labor. Then it becomes a lump sum contract or a measure and value kind of a item rate contract. It could be anything. So that's how the construction contracts are made. The contract management is actually a real art. Maybe we can call it art or we can call it science, but it's actually a very important thing. But most of the time, we see that the contracts are getting into disputes and claims and long winding arbitration, or even the enforcements taking 7.5 to 8 years in Indian context. All this starts with a poor contract management at the beginning. One important thing, whenever we talk about contract management, we have to think about life cycle management. That means what I'm trying here is the pre-contract activities have to be properly carried out. Most of the time, the PSUs, the government agencies, they don't provide the kind of importance to the pre-award activities. Then the contract is awarded, the tender is out, the contractor is on board. Then a lot of problems which they have not taken care at the time of pre-award, they are all surfacing. Then each party is fighting that it is not my risk, you are priced your that risk, and you have to do that. So this is where the most of the problem happens. So the pre-award activities are properly carried out, complete the design, ensure that there are no unknowns at that point of time. Of course, there could be unforeseeable things that could be managed later, but at least we are clean on the paper. We are sure about everything. Then if you proceed with a construction or a contract, whatever contract, then we have lesser and lesser issues as compared to the contract which is rushed through. Now, basically, as I told, the contracts are full of risks. I'm not talking about health and safety risk alone, but there are a lot of contractual risks. If the party who is designing the contract may have a design risk, then escalation risk. So there are a lot of things are there. So basically, we draft a contract to ensure that what are the expectations of the parties. Who's the best position to undertake that particular risk? Okay, then if there is a breach, what are the remedies? And we have to ensure. This is what exactly we want. Basically, contract is actually the law created by the parties to define how they want to go about it, right? So this is how they art of the contract. So basically, we need to have a clarity in definitions. So where to use the boilerplate clauses, where to be bespoke, that's quite important. That's very important. The liability part of that dispute resolution force majeure clauses have to be taken care. And if at all, if it's in a contract of data privacy or international investment, we need to talk about the GDPR and bilateral treaties. And if it's a construction contracts, what are the best practices? So basically, we need to learn from the best practices, what is happening globally. So we need to adapt. It's not that one size will fit all. Like, I don't think that's going to be the case. So whatever the domain we are doing for, that's where the lawyers are today. They have to upskill themselves in the various areas because they have the basic legal skills. Fair enough, that's fine. But when it comes to these specialized areas, do they have that kind of expertise to ensure or to foresee the kind of risk which is going to be there, and how do you protect the party or the parties? I feel that the contracts have to be drafted in a fair and balanced manner, not protecting the party who is asking you to draft the contract. That should not be the case, actually, because these are all highly risky contracts we are talking about it. So it has to have a fair and balanced risk sharing have to be there to start with. Now, when it comes to engineering, construction, consultancy, design build contracts are all there. Then the rights and liabilities, risk, dispute resolution, we are talking about it. So basically, the commercial intent, see, why we draft a contract, there is a commercial requirement. The parties wants to have, I want to build the government wants to build an airport. So there is an intent. They want to make sure that that is required because of the kind of the city is growing and that is required and the airport have to be expanded. But they have to ensure that legally the contract should be enforceable so that it protects both the parties. So the poor drafting could be a lot of issues. Of course, this Kailashnath Associates is one of the classic case, which you might have been familiar with that. So contract was poorly drafted with the forfeiture clause was not very clear. So there was a conditional acceptance, but the clear allotment was not given. Then the contract was terminated. So it was considered that it is not actually a breach because the part Kailashnath did not fail any obligations after the forfeiture. So basically, because there was no concluded contract, the courts decided that Section 74 cannot apply. So they said that the DDS termination of the contract was arbitrary and it was violating the constitutional law. So this is one of the simple cases where the contract was not properly drafted that could lead to a lot of unknowns at that point of time when it goes to the court's rigorous review and the judgment and the arguments, right? Now, what are the key points in a contract? Basically, we want to allocate the risk. We want to allocate the duties of the parties. What are the rights and responsibilities? And finally, we need to have a predictability. We can't leave the things as they go, and when there is a problem, we will handle that. That is not a great idea. So that's why if you look at international contracts, there is a very clear provisions. This is what the contractor or the employer is supposed to do. If they don't do that, these are all the remedies for the contractor. Sometimes it could be only the extra time because there is a delay in the project. Sometimes it's time will be given and additional cost will be given. Sometimes time, cost, also the profit will be given if there is a substantial breach. That's how we look at the construction contracts or international contracts. Now, when it comes to cross-border context, there could be a lot of problems will be there. There's cultural differences. That's one of the major areas which I would say, because I've seen contracts in the Middle East, also in the Far East. When we work with a multicultural environment, what's the Western world, Europeans or Americans think, that is very different from what Asians think and what is their cultural requirements are. In fact, even if you put a notice, if the other party is a map engineer or the contract administrator is an Englishman, he may not really worry about that because the contract says that you need to put a notice and you are providing a notice. Whereas it's not the case if you have an Arab or an Egyptian or somebody, they are very sensitive. When you are putting a notice, they think that you are contractually aggressive. You are trying to take advantage of the situation. So they don't welcome that kind of a, you are only doing the contractually what is told, but that is not very welcome when it comes to that. So it's more than the written text and whatever it's there in the contract. The translation, the cultural differences could make a lot of difference in drafting and making the contract workable. So any participants can say that what is the most important clause in the any contract what they have drafted? Any suggestions? Anything which you feel that it's an important clause for you? Just to make sure that it's not just a monologue. We are just having some kind of involvement. Yeah, somebody has raised a hand.
Yes, Prashant Sharma.
Yeah.
Good evening, sir.
Yes, over to you.
I think the scope of work and the definition is the most important clauses in a contract, because in
Okay.
definition you come to know what is to be covered and what is not to be covered. And in the
Okay.
scope of work, you will get to know that what is the scope of work and what our parties are liable
No
to
problem.
do.
I understood. Any other thoughts from maybe from a legal professionals? What they believe that it's the most important clause in any contract?
The people are putting in the chat box dispute resolution clause, consideration,
Fine.
duration,
Okay.
and the
Fine.
scope of work. Okay, sir.
Okay. Yeah. See, somebody said every clause in a contract is important, of course. But if you really ask me, think about it. I would say the dispute resolution clause is the most critical because when everything fails, that's the only clause you are going to hang on to, right? If your dispute resolution clause is not properly drafted, then you are going to have a lot of trouble. You are going to go to court to decide that even your arbitration tribunal, how you are going to set up that. So you need to ensure that the contract is drafted. Of course, the parties' obligations, rights, and responsibilities and remedies should be very clear. Definitely, the risk sharing have to be clear. The dispute resolution clause have to be drafted without any ambiguity, which will ensure that if everything fails, you have a safety net to take care of that. But generally, we all know about that. We don't want to have an ambiguity in our contracts. But having said that, I've seen a lot of even international contracts when it bespoke, they don't really write in a very precise manner. I will tell you one classic example in the construction contracts. Every time they write, the work have to be done in accordance with all kind of standards. They don't want to put one standard, American standard, British standard, European standard, Japanese standard. Every standard they know that. And finally, to top that, they'll say that best industry practice. Nobody has defined what is a best industry practice so far. So when you try to draft that, it is not precise. If you want to say that this work have to be based on ASTM Section 8, you write ASTM Section 8, that would be the criteria for you to do to the final testing to do the acceptance. But if you're writing the best industry practice, on what grounds somebody would be able to tell that whether it is a best industry practice or not? So what is a data? What is an investment? What is called a substantial completion? That these are all the things normally fought at the end, that Each party will have a different interpretation of that. So when you are drafting a contract, it has to be very clear that what you mean that exactly when you are writing particular thing. When you want to do a substantial completion, you need to definitely define at which point of time the works can be considered as substantially complete and ready to take the next step. So that's very important. So this is actually a case, Rainy Sky and Konkman Bank. Actually, it's an English case. Basically, this is what happened. Actually, it's a shipbuilding contract. So there were some advance payments made against a guarantee. Then that shipbuilder has become insolvent. The refund guarantees covered the insolvency or not. It was not very clear. So both parties were doing their own interpretation. The court said that we have to apply the common business sense principle. This we could have seen that in most of the English case laws, they call it a common sense principle or bystander principles. They talk about it. We have to remember we cannot go to court every time to interpret a badly drafted contract. That may not be at least not in favor of one party at any point of time, right? If the words are capable of more than one meaning, the court will adopt the meaning consistent with the common sense. That's fine. But why can't we take care while drafting that what we want to really intend to do that? So that's very important for us to do that. Similarly, the risk allocation. So which party is going to be taking the risk? One small caution to the legal professionals. So whenever a party comes to you to ask to draft a contract, you believe that you need to protect that particular party. So you try to pass on all the risk back to the other party. Maybe you think that I don't want to have any risk for the party I'm representing. That may be the thinking behind that. But definitely, if the other party is really prudent, if you're going for a tender, if you put all the risk back to the contractor, if the contractors are all wise enough, they are going to price the risk. They are going to put a contingent amount for the risk. So then what happens when that is happening? Then you are going to have a bid which is going to be expensive than these risks are fairly shared between the parties. One classic, I will tell you, in a turnkey contract everywhere, even in India, we want the contractor to undertake all the unforeseen risk also. The word unforeseen itself is very clear. I cannot foresee at this point of time at the time of tender, right? So if that is the case, if the employer cannot foresee a risk, I don't know how the contractor would be able to foresee and he will be able to do that. So that is not going to be really possible. So you need to ensure that it is not a great idea to pass all the risk. Maybe the fundamental principles of risk sharing is the risk should be assigned to the party who is in a best position to manage it. This is how we deal about the risk management. So it could be a data breach, it could be a regulatory expropriation, or maybe site conditions. So what are you going to do? How are you going to manage this? Again, there's a case law here, Occidental Petroleum versus Ecuador. It's an exit case actually. Basically, the drafting of termination and stabilization clauses were not properly done. So basically, the contract was made, and after that, they were trying to bring in another agreement, a Canadian company with a 40% economic interest. Does it involve to assignment, or it's just an economic interest? That was kind of a argument. But the other party, the Occidental Petroleum, they terminated the contract automatically because there was a clause that if there is a violation, there is no notice provisions. They said they will terminate the contract. But then it went to the court, and there were a lot of arguments whether it was an assignment, whether it was a transfer. The contract did not define that. So then when it comes to termination, these kind of contracts used to have a cure period, kind of a notice. Before termination, you need to follow that. Then the failure to expressly protect the investors, that was also not there. And finally, because of all that, the bilateral treaty obligations was not done. So because of all that, they were asked to pay $1.77 billion to the innocent party, which was never thought. They thought that that could not be the case, but they end up paying that kind of a money for a poor drafting or poor risk sharing. So that's why whenever we want to do that, if at all you want to prohibit the transfers and assignments, that has to be very clear. There has to be, the termination is a very, very critical one. You can't think that He's not performing, I'm terminating the contract. There are times I've seen 9 out of 10 such kind of terminations are challenged in the tribunals or even in the courts. Mostly the termination procedure is not followed in most of the cases. So it becomes like an unlawful, wrongful termination, and the innocent party is gaining. Although he may not have performed, the owner have a right to terminate, but you need to go through the procedure of termination. And if you don't do that, probably it may haunt you back. That's what I've seen in most of the cases. So the termination rights are proportionate to the severity of breach. That's why we tell that we don't jump and terminate a contract for every breach. It has to be really substantial. Then only we will be able to demonstrate that the breach was substantial. There was no other cue. The termination was only the cue. Otherwise, it is not going to be. The contractual term with the treaty protections, that is very important when you're doing.
Sir,
Yeah.
sir, sorry for interruption, sir. Some participant messaging, like, slow pace, sir. Going fast a bit.
Okay.
Yes.
Fair
Okay,
enough.
yes.
No problem. That's why I asked. Did I go? Do I go fast? Fine.
Yes, sir. Yes.
No problem. I can slow down. So basically, whenever we talk about a risk sharing, we need to think about, is there any bilateral treaties? How these things would be looked upon? Because investor to state or state to state arbitrations are not easy. So these contracts are highly difficult to see that how the risk sharing is and how these things are going to develop in a dispute resolution forum at a later point of time. So it's very important. This exit case says $1.77 billion. Of course, later on it says it is reduced slightly. It's because the contract was not drafted well. And second thing, the pre-termination procedures were not reasonable in the contract. So the tribunal felt that it was not the case to be done. Coming back to data privacy kind of contracts, here, still it is a very, very new field. We are not very clear about what is going to happening, and still we are talking about AI, and it needs to be regulated. We want to have an AI law, and how these are all going to be taken care. It's still in the process of developing and becoming a kind of a more and more reasonable and understandable domain. So whenever we are drafting contracts, generally the one of the greatest risk here is the data privacy. So because GDPR is actually for the European countries, they work with that kind of an agreements. In India, it is there, it is developing, but whenever we work with the international forums, so what are the applicable clauses and how are we going to manage that? That needs to be considered. Similarly, when we talk about international investment, we need to think about, is there any BIT there? What there, and is there any case laws before that, and we need to take care of our drafting. So those things definitely comes to my mind. Coming to the construction contracts, I think it's not no-brainer. I don't think we should be doing any bespoke when it comes to construction contracts. There are well-established international contract forms are available, like FEDIC, JCT, NEC, Institute of Civil Engineers. A lot of things are there. It's all tried and tested. In fact, we are using FEDIC predominantly in India because most of these projects are all funded by a external third party like Asian Development Bank or a JICA or some other development authority. Otherwise, we never had any motivation to use the FEDIC. We felt our bespoke contracts are more than enough for us. But there are a lot of advantage when you are working with the international firms, because one is these are all time tested, and second thing is the risk sharing is very balanced. And there is, if at all you want to do the international tenders, definitely it will welcome a lot of international players to come and work in your country. I remember when we were doing the first solar plant, when we were doing the first solar plant in Dubai, the contract was highly one-sided. No tenderer was willing to quote for that. It was actually a PPP model. So the contractors were arguing, we are putting money. Why should we take this kind of a highly risk contract, and we are not interested about doing this? So a team of American lawyers, they have drafted the contract. So they were really surprised, and they were asked to fly in. 7 of them came, and there was a lot of meetings happened, and finally the contractors were asked, the bidders were asked, what do you want? What contract do you want? They said, look, we know that this is a risky contract. The owner doesn't want to take a lot of the risk with them. Fair enough. We are ready to take a FEDIC Silver Book contract, which is for an EPC or a turnkey. We are ready to take a standard form turnkey contract because although it is riskier compared to the standard forms, we are ready to take that because we are aware what kind of risk we need to expect. But if you put everything in our plate, we are not interested to do that. In fact, that was changed. After that only the contractors were willing to participate in the tender. So in this case, actually, where we are talking about data privacy, this actually involving the Facebook Ireland, the standard contract clauses were there for the covering the data transfers, but actually they did not ensure that sufficient data protection. So what the court said, you may have the boilerplate standard contract clauses, but they are not enough. The parties must conduct specific risk assessments and they have to draft bespoke contract terms for compliance because what is acceptable to one party may not be acceptable to another. So you cannot have a boilerplate clauses everywhere and say that this is what we follow. So each party have to undertake their own risk audit, ensure that what is their stand and what is their protection they are looking for. So that should be the expectation to be included in the contract. Then we may not have any unknown risk at the later point of time when there is a breach and we want to fight with the other party. Okay, that is about drafting and ensuring that you are giving importance to the BITs and GDPR and even the international contracts. We need to see that the contract clauses should be legally enforceable. So that's very important because it's okay in common law countries, mostly the contracts are all enforceable. But if you're working in civil law countries, there are some provisions in the civil code which are all mandatory. The mandatory contracts, mandatory provisions in the code cannot be superseded with the contract. So it actually works as a 3-tier. Mandatory provisions will be the top tier. The contract cannot change them. Then you have your contract coming in. Then the non-mandatory provisions will be like a safety net. If your contract is not clear, then the non-mandatory provision may fill in the gap. So that's for the civil law countries whenever you are trying to draft a contract. However, if it is going to be a common law, mostly we go by the contract, what we draft. But generally, whenever you are drafting a contract, you need to think, will I be able to explain to a neutral party like a judge or a tribunal to enforce this? Is there any public policy violation will be challenged on that? How are we going to work on that and work around that? So that's very important. So basically the severability clause is very popular. So that's important to know that because your arbitration clause have to be ensured, or a dispute resolution clause is a severable. So that's important to know about that. And what is the jurisdiction? When we talk about jurisdiction, sometimes it may be an international arbitration. So you need to have the seat properly mentioned in the contract. We had a long sessions of arbitration capacity building workshops. A lot of speakers spoke at a length about the importance of seat and other things. So the governing law, the jurisdiction, all these things are very important. So whenever we draft a contract, we need to ensure that tomorrow these contracts would be possible to enforce in the jurisdiction which we are expecting. That's very important. So last but not the least, as I told, the fairness, right? See, good contracts have to be a product of balanced negotiations. So in fact, people say that each party should feel that they got a fair deal. Then only we can say that the contract is reasonable. If any party feels that they got a bad deal, then that is not going to be, that sour feeling is going to continue and it is not going to be good for the performance, right? So that's why whenever we draft in a one-sided contract, you need to think this may attract more risk contingencies by the other party, and that contract may be considered as unreasonable in the eyes of a neutral third party. Maybe sometimes you may be familiar with the contra preferendum rule. Tomorrow, if there is an interpretation issues, perhaps it may be interpreted against the party who drafted the contract. Are there any questions? That's why I want to comment. Is the speed is okay now?
No, sir. Yes, speed is okay, sir. If you want to take questions, sir, or later on.
One or two questions I can take to break the monotony.
Okay, sure. Yes, we can take
Yeah.
oral question. Sumit Daya. Sumit.
Hello. Good evening,
Yes,
sir.
Yeah,
yes.
Sumit.
Sir, my question is it compulsory to notarize the contract? Because I have seen many employer contract where some of the employer did not notarize the contract, as that is all happening through the mail. So some of the employer do the notarize the contract. So any difference between them?
No, notarize means, are you talking about stamp duty and all, like in Indian
Yes,
construction
yes.
contracts? Yeah, it has been settled in the law that construction contracts required to have a stamp duty done. Otherwise, your arbitration, and finally, you may not be able to enforce. So government contracts, yes, it needs to go through some kind of the legal requirements. But generally, the commercial contracts, there are no requirements for any notarization and all. In fact, when we talk about data privacy or international contracts, we don't do any such thing. But it all depends upon the jurisdiction where you are going to enforce. So you need to ensure that you don't violate the regulations of the jurisdiction where the enforcement is likely to happen at the later point of time. That may be the more reasonable, balanced answer.
Okay. So suppose the jurisdiction is in Delhi or India. So I don't know what is the law say here, but
It
what's
all
your
depends upon the parties, how it is going to be, what kind of. But generally in India, commercial contracts require to have coming under the stamp duty. That's what I understand currently.
okay, so but the IT Act also said all the emails, all the contact through the
No,
emails.
no. They're all. I would say that they're all recipe for disaster. I don't think you should be doing those kind of things through emails, through WhatsApp. I don't think that's a legal contract. Said contract is a legal document. You need to give that kind of an importance. It has to be properly drafted, witnessed, properly executed, so that there is a certainty. The emails, WhatsApp, and all, I would strongly discourage those kind of contracts.
Okay, sir. Thank you very much.
Yeah.
Yes, another question, sir. We
Yeah.
have discussed something on typical provision time is the essence of the contract.
Yeah, we can talk for another week. Time is of essence, right? See, again, there are judgments as for and against. One way of looking, you know that lawyers don't agree everything in every situation, right? So if there is an extension of time clause is there in the contract, then probably the thing is it's not a time is not of essence because you wanted to provide. But I don't think we will be able to cover those kind of individual specific ones, which are all highly debatable, and we must have a debate rather than discussing. So, but if in a construction contract, unless there is a strong perception that if there is going to be a delay, that project will be totally useless, then I don't think any construction contract will be time is of essence. That's what my view. But I know very well that there could be a counter view by many of advocates who are all here. So any other questions or can I proceed?
So we'll take it later on. Please proceed.
Fine. So when it comes to drafting methodology, probably I thought I'll just give a small checklist kind of thing. So I am talking about a bespoke contract. You are drafting from a plain paper and pen. You are starting something. I'm not talking about standard forms because in construction contracts, we normally don't draft contracts. We only adapt. All we want to do is we take a standard form, we adapt, we only modify the particular conditions to make a contract. We don't do from scratch. But that's the standard form of contracts. But when you want to draft a contract for a parties, so what are their objectives, what they want to do? Remember, the commercial sense have to be prevailing first. So each party have something to offer and they want to mutually come together and they wanted to ensure that one party gets the service, the other party gets the consideration, that's the money. So to do that, so basically what they want to go about it, how they want to go about it, that's what they are looking at it. So basically, as I told, you need to look at what are the risks there, what are the commercial realities. And one more important thing, just because you are a very big party, you cannot take the subcontractors and simple small suppliers for a ride. That's not considered to be. In fact, I will tell you, in Kuala Lumpur, in Malaysia, there are cases where the Petronas have been pulled up by the court. They told that you are a very senior player, very responsible employer. The what you have done to your subcontractors is not reasonable. So because when you are a bigger party, when you are a national building party of that nature, you cannot use your position to draft a contract, making sure that the other party is taking all the risk and they are going to be in the wedge of losing a lot of money. That's not really acceptable. So when you are drafting, of course, you can use templates. These days, even ChatGPT can give you wonderful contract drafts, but you have to be careful because are they taking care of all the situation? So you need to always take with a pinch of salt, amend it wherever it is necessary. The clause heading summaries, those are all cosmetics. You can always do that. Then finally, you wanted to negotiate. Generally, a good contract should be negotiated and agreed. It's not that take or leave. I've seen that a lot of times the big main contractors, they send a contract completely signed by by that party. They just ask the subcontractor to come and sign. We used to refuse that. In fact, we used to consider that that's a draft contract, and we used to start reviewing that and provide a lot of comments. Of course, they used to get very upset. They say that this is our standard contract. For 35 years, we have been using that. How can we ask our head office to make a change? So we say that, look, this contract clauses are not acceptable. When you are signing a subcontract, if the main contractor doesn't have any obligation for a particular risk in the main contract, how can you ask a subcontractor to assume that risk? So those kind of things definitely need to have a negotiation. So then finally, you need to track the changes and ensure that you have the final version for the signature. You have to monitor your obligations, ensure that you are not making a mistake. If at all you want to amend a contract, there has to be a mechanism to amend the contracts. Who has the authority? The protocols, the authority protocols are very important. Similarly, it's very important to keep records for the claims and later on for the disputes. So it's always better to keep a kind of a drafting checklist depending upon the type of a contract. Probably you can tick box them so that it may be a good idea to ensure that your contracts are all complete. Again, about the appendices and annexes, I'm very much against putting everything, whatever you can think of under the world, as part of the contract and do that. I've seen that in one particular project in Jeddah, the traffic study which the employer conducted was put as part of the contract. I said, what is the relevance of this particular information? They said, no, we have this, you have it as part of, and it's a design build contract. So how we can ensure that those kind of relevant information are part of the contract. So we have to be cautious about what we are trying to bring in as part of the annexes and appendices. So final takeaways, make sure that your contract clauses are tailor-made about the subject matter and the jurisdiction. Whenever you are drafting a contract, a lot of people say that you are a very negative thinker. Like normally I used to say that contract, you need to look at the dispute resolution clause and you need to negotiate that. And they say that, look, why you think that we have a dispute? We are all gentlemen. We may not have any disputes at all. Why do we talk about claims and disputes at the time of entering into the contract? That's a normal argument between the contract managers and maybe the sales managers or even project managers. They think that we are unnecessarily making it a big thing, but that's not the case. We have to ensure that we have to anticipate for the bad things, and our contract have to be taking care of such kind of a bad day. If there is a dispute, that's the only clause you are going to rely upon. It's very important. So don't make it overly complex. It may be difficult for you to interpretation, and tomorrow that may be misunderstood, right? The most important thing for the lawyers and advocates is actually write in a plain language. Today, everywhere people are expecting you to draft contracts in a plain language. If you look at international contracts, especially in the construction contracts, they say that very clearly. We want these contracts to be drafted by the engineers because it's going to be read by the engineers. We want to review by the legal professions only for a precision. Is it okay? Otherwise, if it's going to be completely legalized, it's going to be not effective. So that's what basically you need to be remembering that. So I have one clause, basically a kind of a standard clause. Then I'm trying to show you that how this can be drafted for three different domains. Three different domains. So I'm trying to minimize this so that I can see the screen. Yeah. So basically, this is an indemnity clause. The service provider shall indemnify and hold harmless client of any claims losses from the use of AI-powered data analytics services provided under this agreement, including any breach of applicable laws or third-party rights. So it's a very generic one. Let us say that if it's a data privacy domain, how this could be written in a more formal manner. We are bringing in the GDPR complaints, cross-border data transfer mechanism has been brought in, notification and obligations have been brought in. So automated decision making is also brought in. So the service provider shall fully indemnify the client, fines, penalties, losses, claims arising from the breach, any applicable transfer regulations by using this AI-powered data analytics. So this is a standard vanilla flavored kind of a clause could be drafted for a particular domain rather than leaving it very open. Let's say that you are going to use it for an international investment. Here you talk about the bilateral treaties, if it is there. What are the investment protection standards? You want to talk about expropriation. What is the role of technology transfers? Where is the jurisdiction? Is it going to be under the INCITRAL or ICSID? How are you going to do that? So basically, those things have to be brought in, and that clause have to be properly drafted between the host state and the investor or state to state. Similarly, when it comes to construction law, basically you wanted to talk about the liabilities arising out of errors. So how this is going to be reliance of delay analysis or claims quantification, tech-based one, or you want to use that fatigue-based risk allocation. So you need to really think what is the domain I'm going to be drafting for and how I can adapt to make sure that it is a robust drafting and taking care of all the uncertainties that could arise tomorrow from a particular situation. So that's very important for us to make sure that contract clauses are drafted with that. So any questions at this stage? I have concluded the basic part of contract drafting. Now, what I have is a small portion of 4 or 5 contract principles. That's what I'm going to be. So if any questions related to contract drafting, we can take it before we move on to the second part of the session.
Sir, let me read out a couple of questions.
Yeah, please.
Sir, please explain how NDA, the indemnification clause, can be drafted, specifically for the consequential damages can be incorporated. Most of the information receiving parties do not agree to consequential damages for various breaches. NDAs related to NDA.
The consequential damages are very difficult because at the time of entering into the contract, it is very difficult. We call it a remoteness of damage. In any jurisdiction, even including civil law provisions, any consequential damage or the damage is remote. That is not part of the damages which a party can claim. I don't think it would be fair to ask for a consequential damage in any contract because it could be both the sides. Like, for example, if you think that, okay, you are going to make a factory and you're going to sell, and there's going to be some losses for which, if you come to construction contracts, we have a pre-estimated, liquidated, ascertained damages are there. So that's the thing. It's not more than that. So there is a cap on that. Okay, if you want to have an unlimited, unliquidated damages, again, you need to prove that the losses have really happened and it is not remote for the parties to identify at the time of entering into the contract. I think remoteness of the damage and the consequential losses are always, irrespective of civil or common law jurisdictions, they are all outside the purview of the contracts. I think it's not fair to expect that to be part of the contract. That's my take.
Okay. Sir, please go ahead, please, sir.
Yeah. Fine. So basically, again, the contract law, the Contract Act, we, unlike the lot of other jurisdictions of a common law, it's very funny actually. The English drafted a Contract Act for us, of course, for Malaysia also, but the parent UK legislation, they don't have a Contract Act. The contract law is actually a judge-made law and it is evolving all the time. Of course, they have some minor Unfair Contract Terms Act, Misrepresentation Act, those kind of things are there. But generally, they don't have a codified act like what we have as a common law. That is very strange. How it was possible for other common law jurisdictions to work and why do we have to have? There are some benefits to have a codified one, definitely. So it is less interpretation. So you know exactly what is there in the act and you go by that, unlike the common law jurisdictions, which doesn't have a contract where you need to do the law may be evolving over the time. So that's fine. But when it comes to that, so formation of the contracts, we talked about it, capacity, free consent, it has to be a lawful object and consideration, then performance of the contract and breach, basically the remedies, all these things are covered under the Indian Contract Act. As I told you, in common law countries, most of the other common law countries, in fact, my contract law professor, when I was doing my LLM, she told the English law, wherever you want to know about which country is a common law, you can easily find out. The English took three things with them. One is their language, the second is their legal system, the third is the cricket. So a cricket playing country, most likely to be a common law country. So on maybe English speaking. So if you really look at it, that's the case. So for some reason that we have a contract act, whereas those common law countries, except maybe Malaysia, they've stopped up only using a judge-made common law as part of the contract law or contract act. Now, I told you there are only few sections I'm going to be just looking at it. See, agreement and restraint of a trade. So that is actually, it's void even if it's partial. Why I choose these 4 or 5 sections is basically there is a clear distinction between the common law in other countries and the Indian provision. So you can go and Google yourself and you can find out how these things are considered in other jurisdictions vis-a-vis in Indian jurisdiction. So in this particular case, basically that Gujarat Bottling and Coca-Cola, there is a case came the validity of the negative covenant. The restriction during the term of valid agreement is not hit by section 27 if it's reasonable. After the termination, the restraint of trade cannot be there unless it is reasonable or if it is a post-contract non-compete. So actually that is unenforceable in India as per some legal scholars. So that's, if you are drafting something for that, restraining the trade, that you need to be careful that what is the duration and how you are going to be drafting that. That's important. The doctrine of frustration is again is little different from other common law countries. So there is a case law again here. So basically here they didn't consider that the contract could be frustrated because it is not impossible to perform. It is definitely possible to perform. So there is no need for unilaterally cancelling the contract, saying that it is frustrated. So they said the contract is not frustrated. It could be performable. So they said the frustration does not apply in this particular case. So the impossibility, including the impracticability and purpose of frustration, there is a difference between the view of English common law and the Indian section 56 under the Indian Contract Act. So basically, this is what it is. Impossibility or unlawful acts will come under the section 56. It has to be practically, the temporary delay or hardship is not considered to be a frustration. That's what exactly. See, the government requisition does not permanently prevent the performance. So they said it could have been done later. If we can't perform there, probably that the contract could be performed later. The contract was not frustrated. So the court said the party cannot avoid the contract, merely the performance become harder or commercially less profitable. That's what exactly we need to understand. So it has to be a very strong reason for a contract to be frustrated. So compensation for loss caused by a breach, again, this is a very famous case. We keep hearing now and then, ONGC and saw pipes, the pre-estimated liquidated damages. So even without a proof of actual loss, if it is reasonable, they will provide. And again, the liquidated damages, again, is a Pandora's box. There are judgments for and against. There are some judgments say that still it has to be proven. And some cases it says, if it is not possible to prove, then the genuine pre-estimate in the contract could be considered as good enough. So, but I think in Malaysia, it has become, at least now for the time being, it has been very clear the liquidated damages need not be proven. The actual loss need not be proven. As long as you prove the breach and you followed the termination procedures or the notice to deduct the liquidated damages, without proving the actual loss, you would be Cubic Electronics. There is a famous case, you can go and read that. So that kind of a clarity is still not there in India. So Section 74 is also the similar reasonable compensation. So that's what I told. As long as it is a genuine pre-estimate and it could be demonstrated, so no need to prove the actual loss. So right to compensation on rescission, then again, Indian Oil Corporation versus Amritsar Gas Service. So the termination was contractually permitted. Yes, that's not a problem. It is not a breach of contract. So the section 73 was not applicable because it was a contractual remedy. But once it terminated, the general damages, nominal damages have to be provided. The anticipated profits or loss of business are not to be considered. So that the tribunal was trying to provide, and the court said, no, that is not the case. Whenever there is a right to compensate is there, in a contract where there is a right to terminate is there, the nominal damages are applicable. And that's the reason that it was provided, not the anticipated profits or a extended loss of business profits were not given in this particular case. So I think whether it's fast or slow, maybe like a 2020 match I've completed. Probably I might have gone a little faster because I was a little worried that whether I would be able to complete within the given time, but I think I've done. So this QR code is for you to scan and provide me a feedback. I would appreciate if you could do that. And the floor is open. If you want to ask any questions, I'm available to take the questions. But I would sincerely request, please provide your feedback. It will be very helpful for me to update my presentations.
Okay, sir. So to take one question. Yes, sir. Sorry, name is not there. Name is iPad. So sorry. Yes, please.
Yeah.
I have unmuted you.
Hello.
Yes, 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 please.
Yes, sir. Good evening, sir. This is Dr. Prasad. Thank you for this session. And I have one question because I'm deals with the infra tenders based on the FIDICs and which is updated in the particular conditions that contractor will not be avail any monetary claims based on the extension of time. Okay, means any time extension will be there from either side. EOT can be granted only as a matter of time, not as a matter of cost. But some contractor many times having that LD clauses means X% limited up to the 10% cap. Then whether it is means this seems as a impartial. And second thing that if the delay is from employer side beyond some limit, so there should be also limit for the extension of time monetary claim. If the beyond certain limit time is extended, then how the contractor can perform?
You are asking a legal opinion. You are not asking a doubt, right?
No,
No.
The general doubt.
No. Such things cannot be. General answer cannot be given. It has to be looked upon the various things. how the
Okay.
parties were aware and what is the parties considered to take the risk. So I
Okay.
can't jump and tell that it is completely unreasonable and you would be entitled. I cannot tell that. But there are grounds to contest. I can only tell
Okay.
that.
Okay.
But again,
Okay, sir.
that is for the council to look at the case and strategize on how he wants to do that. So if I am advising an employer, I would say that don't include these kind of clauses, which may give
Yes.
you a false security, but that is
Yes.
not reasonable.
Correct. Yes. Yes.
But that is again, it's not a legal opinion. I have to put a caveat, right?
Okay. Okay.
Okay.
Okay, sir. Thank you.
We
Yeah.
will take up last question. Like, sir, is it necessary to include clauses expressly on liability of subcontractors in construction contract?
Generally, there is a privity of contract. You are a main contractor, you are liable to the client. How do you get the work done? By a subcontractor or yourself? That is between you and your subcontractor. So the lead contract or the main contract between you and your employer, in no way it is going to be considered about your subcontracts. But every contract will have a liability, every contract will have its own repercussions. So you normally used to have a step down clauses. Like if the subcontractor doesn't perform in front of the employer, I'm going to be failing. So then if there is going to be some repercussions coming on that, then lawfully I should be able to pass it on to the subcontractor. So that's a normal expectation. But there are a lot of things we need to look at drafting a subcontract and how this is going to be fair and reasonable between the subcontractor and the contractor. So that's the short answer, I would say.
Navneet, over to you.
Yes, thank you so much, sir. And on behalf of organizing committee, I would like to extend sincere gratitude to you, sir, for delivering such a thoughtful and enriching session today. We are truly thankful to you, sir, not only for accepting our invitation, but also for taking the time to guide and inspire all the participants. Thank you so much, sir.
Thank
Thank
you.
you. Thank you. Thank you. Please give the feedback.